All right, today we're going to finish off the lecture for this week, which is Chapter 35, Management Structure. We talk about the government structure. What we're really talking about is the corporate governance of corporations in particular. We're going to look at the role of shareholders, so what voting rights the shareholders have, how do shareholders enforce their rights. And then we're also going to talk about the role of directors and officers. So the function of the board of directors, the election and tenure of the directors, how the directors exercise their functions. And then we'll talk about officers and also about the duties of directors and officers in general. So let's begin by a general overview of the structure. The corporate management structure, as required by state and corporation statutes, is in essence a pyramid. And so the way that the structure looks like is as follows. So at the very top we have the officers. The officers are the ones that run the day-to-day operations of the corporation. So when we talk about management, really what we're talking about most of the time is the officers. They're the ones that make decisions on behalf of the corporations. Then below that, we have the board of directors. And what's interesting is the board of directors are the ones that elect the officers. And the board of directors also declares dividends. Again, as I mentioned, they delegate authority to the officers. So they're the ones that pick them or that select them. They manage the business of the corporation. In other words, making really strategic decisions for the corporation. Where is it going to go? They select, remove, and determine compensation of officers, and that's what I already mentioned before. Below that, at the very bottom, the base really are the shareholders or the owners. They elect and remove the directors. Usually that happens at the annual meeting. And they also approve fundamental changes. So if we're going to change the business model of the corporation or anything that's really a material change, then the shareholders also have to approve these, what we call fundamental changes. So this is the way that the management structure of corporations is set up. So the statutory model of corporate management, although required by most states, accurately describes the actual governance of only a few corporations. In other words, some of the bigger corporations are actually structured that way, and that's how they function. A lot of the smaller corporations or entities don't function that way, only because they're not as sophisticated. Technically, the officers and the directors would be the same in what we call a closed corporation or a business type or a family type of corporation. Now, a great majority of corporations, as I mentioned, are closely held. They have a small number of stockholders and no ready market for their shares, right? They're not sold on the NYSE. And most of the shareholders actively participate in the management of the business. So again, that's exactly what I was just talking about before, that really there is no difference when we're talking about the small corporations or the closely held corporations. There is either no difference or very little difference between officers, directors, and shareholders. Many times they're all one and the same. Typically, the shareholders of a closely held corporation are also its directors and officers. So again, that's just what I mentioned, but that's what we would actually expect to see. In sharp contrast is the large publicly held corporation, right? Those that are traded on the NYSE or NASDAQ or some other publicly traded market. With a vast market for its shares. These shares typically are widely dispersed and very few are owned by management. So in other words, there are a lot of different owners. There's so many shareholders out there. The shares are dispersed among a diverse group of people or owners. So here's a slide that kind of puts it together for closely held corporations. Usually the shareholders are the directors and they are the officers. The management structure of a typically publicly held corporation is kind of an inverted pyramid where the shareholders sign and return proxies, in other words, for voting, right? They sell the shares. The board of directors delegates authority to officers who ratify, and the board of directors also ratify the actions of the officers. And the officers control the selection of directors, they run day-to-day businesses, and they control proxy votes. So that's a typical. So what about the voting rights of shareholders? Well, when it comes to the management structure of corporations, you can see kind of some of the prior slides, right? This slide is talking about some of the prior slides as to how that actually works. But what is important is that there have to be shareholder meetings. Most bylaws call for, at a minimum, an annual meeting of the shareholders. It's at this annual meeting that the shareholders vote and they actually elect the board of directors. The shareholders may exercise their voting rights at both annual and maybe special shareholder meetings as well. If there's a special decision that needs to be made, if we're going to change the nature of the business that we're engaged in, or any of the other fundamental decisions, then the board of directors needs to declare a special shareholder meeting, and then the shareholders would show up at that meeting and vote, or they can vote via proxy as well, meaning they can give their vote to somebody else to vote on their behalf. So that's actually very, very common as well. So again, it works one of both ways, right? You could have actually direct voting by the shareholders actually showing up to the meeting and casting their vote, or you can have voting by proxy where the shareholders do not actually show up and they mail in essence, their ballot or provide their vote to another shareholder to vote on their behalf. So that's also another common way of doing it. There's the concept of quorum. Quorum means the minimum number necessary to be present at a meeting in order to transact business. So you got to look to the bylaws to see what the quorum requirement is. Could be 50%, could be majority, 50% plus one, could be 60%. I mean, it could be anything that's in the bylaws. But if you don't have a quorum, meaning you don't have that many shareholders present, either directly or via proxy, then you cannot transact business. This is also true. Well, in this case, we're talking about shareholders, so I'm going to leave it at that. But that also applies to the board of directors meetings. But again, we're going to leave that aside for right now. We're talking about shareholders meetings. So at these meetings, you need a quorum, which is a minimum number. If you don't have that, then you cannot proceed with the meeting. You would have to reschedule it at that point. What about the election of directors? The shareholders elect the board at the annual meeting of the corporation, which is exactly what I had mentioned a little bit earlier there. But that, in essence, is how shareholders control the corporation, right? They don't participate in the day-to-day management. But what they do is they elect the board of directors. The board of directors elects the officers. And so that's how the shareholders indirectly control the corporation. Again, we're talking about the election of directors. There's something called straight voting and cumulative voting when we're talking about voting for directors. In straight voting, the directors are elected by a plurality of votes. So in other words, whoever gets the most votes becomes a director. So that's what we call straight voting. In cumulative voting, it entitles the shareholders to multiply the number of votes that they're entitled to cast by the number of directors for whom they are entitled to vote, and to cast the product for a single candidate or to distribute the product among two or more candidates. Cumulative voting is very, very important for minority shareholders. Many, many times, minority shareholders do not have enough power to elect a director or directors through straight voting. They just don't have enough power. So through cumulative voting, and again, you look to the bylaws to see exactly how that takes place, then through cumulative voting, it allows the minority shareholders to be able to elect at a minimum at least one board member, sometimes more. So that's the reason why we have cumulative voting. What about the removal of directors, where the shareholders may, by majority vote, so that's key, majority. So majority is not too bad, right? Not too hard. Majority really means 50% plus one. That would be a majority. They can remove directors with or without cause, subject to cumulative voting rights. So again, we can prevent that through some cumulative voting rights, And again, we look at the bylaws to see how those need to be treated. The key factor here is you can move directors with or without cause, right? With cause means that the directors did something improper. I believe one of the other classes we talked about ultra virus, an act that's ultra virus. That would be an example of when a director may be removed for a cause, or if a director breaches their fiduciary duty, for example, then they would be removed with cause. But they can also be removed without cause, simply because the shareholders don't like the director, or simply just want to remove them. Not because they've done anything wrong, but they just don't like him. Maybe they don't like the way he or she votes, or whatever the case may be. So that may also be possible. I talked a little bit earlier about approval fundamental changes. So again, it's pretty obvious when you think about it, but shareholder approval is required for charter amendments. So if we're going to amend, if we're going to have charter amendments, if we're going to make a major acquisition, right? So we're going to buy another company, for example, or we're going to enter into a new line of business, or for dissolution, right? If we're going to dissolve the corporation, then obviously that's a fundamental change. So that requires shareholder approval. Whether it passes or not, and how many votes you need, it may be a plurality, it may be 75%, it may be, again, you're going to go to the bylaws, and the bylaws will tell you exactly the percentage that you need in order to enact a fundamental change. Talked a little bit about concentrations of voting power. We talked about cumulative voting, but proxy is something that I had mentioned earlier as well. You authorize to vote another share at a shareholder meeting. So in other words, I can give my vote, right, or give the authority for somebody to use my vote or take my vote and vote in a specific way. So again, that's to assist or help the minority shareholders and allow them to pool or concentrate their power. There's also something called a voting trust. It's a transfer of corporate shares, voting rights to a trustee. And then you have that trustee vote on behalf of the trust. It's another option. We don't see that as much as we see proxy or cumulative voting, but it's still out there. There's also something called a shareholder voting agreement. It's used to provide shareholders with greater control over the election and removal of directors and other matters. So you can agree to vote a certain way with other shareholders. So that's how those are used. So when we're talking about the concentration of voting power, and again, this is from a shareholder's perspective, there's three different ways that shareholders can do that, either through proxy, through a voting trust, or through a shareholder agreement. And this slide is actually very, very good because it puts everything together. It tells you what it is, what the formalities are, most required some type of signed writing or signed document. It tells you what the duration is, tells you whether it's revocable or not, and it tells you the prevalence, right? When is it most used, by which type of corporations are the ones that use these mechanisms the most, right? So for example, in publicly held companies, we're more likely to see proxy voting than we are shareholder agreements. Shareholder agreements we see more in a closely held corporation, and really we don't see many shareholder agreements in an open or what we're going to call publicly traded corporation, the big corporations. And voting trusts are used mainly in both, in publicly and closely held. Although I would probably say that the shareholder agreements are by far the most common in the closely held corporations, and proxies are by far the most common in the publicly held corporations. What about the restriction on transfers of shares? It is possible, but the restrictions must be reasonable and conspicuously noted on stock certificates. So if there's any type of limitations, and again, you could put almost any limitation that you want. Again, key factor there is as long as it's reasonable and as long as it's conspicuously noted. And the reason for that is obviously you want whoever is going to be buying the shares to understand and know that there are restrictions on how those shares are going to be transferred. Many times, and it's not just shares, really anything that has restrictions in general is going to have lower value, right? Because it's not as liquid. So there's going to be a liquidity premium, right, that somebody's going to require on that. So the less liquid that the shares are, the less value they have. So restrictions in general lower the value of that particular equity. What about enforcements of rights of shareholders? Where if you're a shareholder, you have the right to inspect the books and records. And again, this one's pretty simple, pretty obvious. As a shareholder, you're an owner. So if you make a demand and that demand is made in good faith and for a proper purpose, then obviously you do have a right to inspect the books and the records. As far as lawsuits, direct suits are those that are brought by a shareholder of a class of shareholders against the corporation based upon the ownership of shares. We don't see a lot of direct suits. We see mainly derivative suits. These are probably the most common. They're brought by a shareholder on behalf of the corporation to enforce a right belonging to the corporation. So in other words, let's say that the corporation has a right, has a claim against someone. And for whatever reason, the officers do not want to bring that lawsuit. A lot of times they don't want to do it because there may be a conflict of interest there. There may be fraud that's involved, and so they participate in the fraud, and so therefore they don't want to sue this other entity. So what happens there is that the shareholder can then sue the other entity on behalf of or in the name of the corporation. What's interesting about derivative lawsuits and what needs to be understood is that the shareholder is not suing in their own name, they're suing in the name of the corporation on behalf of. Since the officers, which are the ones that direct the corporation and would normally have the right to bring the lawsuit, since they're not doing it for whatever reason, then the shareholders are doing it on behalf of the corporation. So any damages that are recovered as a result of that lawsuit, those damages belong to the corporation, not to the individual shareholders. And that's where a lot of people don't understand or get confused with that concept, that you're suing on behalf of the corporation, which means that the damages belong to the corporation. Shareholders also have a right to dissent. A shareholder has the right to dissent from certain corporate actions that require shareholder approval, right? So, and that one's also very obvious, right? I mean, if you, for example, we're talking about a fundamental change and you have a vote, well, you can always vote no, and that is a dissent. And there's absolutely nothing wrong with that, and that's a right that every shareholder in the corporation has. So let's talk a little bit about lawsuits. We have, again, we talked about direct suits and derivative suits. In a direct suit, it's the shareholder suing the corporation. In a derivative suit, it's the shareholder suing a third party on behalf of the corporation. So that's how they work. A lot of times these derivative suits are actually against the officers or against the board of directors for breaching some type of duty. Obviously, the officers are not going to sue themselves. So that's why we have these derivative lawsuits. And here are examples of both direct and derivative suits, the types of claims or actions that would be brought either directly or derivatively. So how does the board of directors work? Well, they get to select and remove officers. That's probably one of their main jobs that they have, and monitor as well, right? The board of directors has to make sure that the strategy that they create is actually implemented by the officers. They also determine the capital structure of the firm. So in other words, they get to determine how long-term assets are going to be financed. Are we going to finance those assets with equity by issuing stock? Or are we going to finance those assets through debt by issuing bonds? So that's what we mean by capital structure. And what percentage of net fixed assets is financed by debt as opposed to equity. So that is a decision of the board of directors. Also, any fundamental changes. The directors have the power to make, amend, or repeal the bylaws, which in essence is the operating agreement or the agreement that controls what the corporation can't and cannot do, unless that power is exclusively reserved to the shareholders. And sometimes it is. If you look at the bylaws will tell you exactly who has the power to do what and how, and sometimes even when. So that's the first thing that you would need to look at is that document, the bylaws, see what they say and see what it says about fundamental changes. But for the most part, the board of directors do have that power to do that. But remember, with a fundamental change, the bylaws usually require, it could be unanimous shareholder approval, could be majority, could be, whatever the documents say. Dividends. Directors declare the amount and type of dividends. So that's also the job of the board. Remember, corporations do not have to declare dividends, but once they do declare them, they become a binding obligation, a contract. Management compensation. The board of directors gets to determine how management will be compensated. Many times they will issue or provide stock options to management in order to create an incentive for them to create shareholder wealth. What about vacancies in the board? They may be filled by the vote of a majority of the remaining directors. That's usually the case. Again, the first thing you need to go to, though, is the bylaws. Many, many times the bylaws will tell you what happens when there's a vacancy in the board. And you could have a vacancy in the board because somebody died, somebody resigned, or somebody was removed. And maybe that the bylaws say that there has to be a special meeting of the shareholders that needs to be declared in order for the shareholders to determine who that next board of director is going to be. But if it is silent, it can be filled by a vote of a majority of the remaining directors, and the newly elected director, in essence, serves out the term of that director. So let's say that directors serve 5-year terms, and 4 years into the term, one of the directors dies. So then the other directors select a person to fill that vacancy on the board, and that person then would serve for 1 year, right? They would just serve out the rest, and then there would be an annual meeting of the shareholders, at which time they would vote on who. And it may be that same director is voted to remain. So that's always a possibility. But there does have to be a vote. Meetings. Directors have the power to bind the corporation only when acting as a board. So in other words, an individual director does not have the power to bind the corporation. So they have to be acting as a board. In other words, there has to be a meeting that is scheduled. And meetings is a little bit deceptive because meetings can be telephonically. They do not have to meet in person. Again, unless the bylaws say otherwise. But a lot of times these board meetings are telephonic, and as long as there's a quorum, or if the bylaws say that 3 out of the 5 directors have to be present in order to transact business, then that's the case. So if there is a meeting, then the directors can make decisions and bind the corporation. In other words, sign contracts, ratify contracts on behalf of the corporation. But again, they do that acting as a board, not as individual board members. What about action taken without a meeting? It is allowed, actually, if consent in writing is signed by all of the directors. So in other words, let's say that for whatever reason the board members are too busy, they can't meet, they're on vacation, but there's something important that needs to be transacted. It may be that if all of the board of directors agree in writing to take, XYZ action, then that's okay. Again, unless the bylaws say otherwise. What about delegation of the board's powers? Usually the board has committees, especially in some of the bigger corporations, we'll see committees. So committees are usually appointed by the board of directors to perform some, but not all of the board's functions. So in other words, what they're doing is they're creating, and a lot of times the officers are members of these committees. So then, for example, there may be a compensation committee. And so the job of that committee is to set the salaries for the officers. So that would be an example of a committee. And there could be several committees, depending, obviously, the bigger the corporation, the more likely there are to be committees. And mainly that's for efficiency, right? We don't want to slow things down. So in order to be efficient, that's what happens. What about directors' inspection rights? Well, directors have the right to inspect the corporate books and records, and that one's pretty obvious. Ultimately, the directors are liable for whatever happens with the corporation, especially under Sarbanes-Oxley and Frank Dodd, right? So that used to not be the case 20, 30 years ago, but now, in essence, as the saying says, the buck stops with them, right? So the directors, obviously, since they are liable, in my opinion, I would actually modify that and say directors have the duty to inspect corporate books and records. Not just the right, but the duty, because if they don't, they could actually be held personally liable in this new regulatory environment that we're in, and rightfully so, because what was happening is, we had all these corporate scandals, people cooking the books and so forth, and the board of directors would wash their hands and say, we didn't know. Well, we didn't know doesn't work anymore, right? We call that the Nuremberg defense, right? I was just following orders. Well, that doesn't work, or I didn't know. You're the board. If you don't know, who's going to know, right? It's your job, your duty to know what's going on with that corporation. So again, I would rephrase it, and I would say that directors have the duty to inspect corporate books and records. There's also other duties that the directors and officers have, but in particular officers, right? They're the ones that run the day-to-day operations of the business, so they have a duty of obedience. They must act within their respective authority, and that one's pretty obvious, right? If you have authority to do X, Y, and Z, then you should not be doing A, B, and C, right? So you got to act within your scope of your duties. Duty of diligence, that one's also a very important duty. It means that you must exercise ordinary care and prudence. So you got to think things through. You got to be prudent about it. You got to exercise ordinary care, just like anybody in your situation would. And there's also a duty of loyalty. We've seen that before, very much related to fiduciary duty. It requires undeviating loyalty to the corporation. So in other words, while you're serving as an officer of a corporation, you cannot steal or take advantage of corporate opportunities or insider information that you gain as a result that you're actually an officer of the corporation. So you can't take news that you learn from your title or your position as an officer and use that for personal gain. That would be a violation of your duty of loyalty. And a shareholder could bring a lawsuit against you individually, or could bring a derivative lawsuit, right, on behalf of the corporation. So we do have something called the business judgment rule. This is very, very important because this is a rule that protects officers when they're acting within their scope of employment. So it precludes imposing liability on directors and officers for honest mistakes in judgment if they act with due care, in good faith, and in a manner reasonably believed to be in the best interest of the corporation. So in other words, let's say we're the board of directors. We meet as a board and we all discuss a certain course of action for the company. We weigh the pros and cons, and in good faith, we believe that the company should undertake Project A instead of Project B. And we do that. We undertake Project A. Well, it turns out that Project A was just a terrible idea and that it cost the company millions and millions of dollars. Can we sue the board of directors at that point? And then the answer is no. The the business judgment rule protects them from specifically that type of a lawsuit. So in other words, if it's an honest mistake or just an error in judgment, even if somebody else would have said, well, when looking at these facts, how can you pick A instead of B? Well, that's a judgment rule, right? I mean, that's subjective. Just because you would have picked B and I would have picked A, doesn't mean that picking A necessarily is worse than B. Now, hindsight is 20/20, right? So it's real easy to look back with perfect information and say, hey, you should have picked A. Well, yeah, had you known that, if you had a crystal ball, sure. But at the time, you don't know. And so that's why the business judgment rule protects. So the idea, though, is for there to have been a thought-out process. What will get the officers and directors in trouble is if they did not go through that process, if it was not thought out. If they flipped a coin, for example, well, that they would not be protected by the business judgment rule at that point. But if they sat together as a board, they discussed the options, they weighed the pros and cons, and then they just simply made a bad decision, then that's not actionable. So they're protected by the business judgment rule, which is really a good thing if you think about it, right? Otherwise, nobody would ever want to serve on a board. Indemnification. A corporation may indemnify a director or an officer for liability incurred if he or she acted in good faith and was not adjudged negligent or liable for misconduct. So let's say again that you take an action and that action results in liability for you, and you got to defend the lawsuit that you're sued personally. But if you acted in good faith and you were not negligent or guilty of misconduct, then the corporation has a duty to indemnify you. In other words, I would have to pay the attorney's fees that you had to incur in defending this lawsuit that was unrelated to any negligence on your behalf or any misconduct. Which again, if you think about it, it also makes sense, right? I mean, if I'm not a guilty party, if I didn't do anything wrong, why should I have to come out of pocket when I was really acting? If we go back to agency law, right? Officers are acting on behalf of the corporation. So all the actions that I took were really on behalf of the corporation. They weren't my decisions. I wasn't making decisions on my own. I was doing it for or on behalf of the corporation. And if that results in liability to me or damages to me, and I wasn't negligent or I wasn't engaged in any misconduct, I was actually acting within the scope of my authority, then the corporation should indemnify me, should pay for my expenses that I incurred on behalf of the corporation. And really, that's the way to look at it. There's also statutes that limit liability. Many states now authorize corporations with shareholder approval, so that's key, to limit or eliminate the liability of directors for some breaches of duty. That's up for debate. Florida is not one of those states, but if you think about it, I guess you do want to protect the officers and directors to a certain extent, but you don't want to make it so broad that you're actually relieving officers and directors from violations or breaches of duties that they have to the corporation. I mean, they're already, in my opinion, officers and directors are already protected by the business judgment rule. So if they're doing what they should be doing, they're protected anyway already. Also, officers and directors, and in particular directors, they have there's O&E, what we call O&E insurance, which is E&O insurance, which is errors and omissions. And that's a type of insurance that protects directors from negligence. Obviously, we're humans, so we all make mistakes. So directors make mistakes as well. And so that's negligence. And so there is insurance for that. And the corporation normally pays for that insurance for the directors that protects them from their own negligence. So if they get sued as a result of their negligence, then the errors and omissions insurance kicks in and would pay for that, including their legal defense. So again, I personally don't see the need for statutes to limit liability when we already have the common law concept of the business judgment rule, and we have insurance to also protect directors from negligence, which would only leave them exposed to intentional acts. And that should not be, there should be no indemnity or statutory protection or even insurance for intentional acts, right? So if I do something if I commit a crime, for example, I shouldn't be protected. So those are my thoughts on these limitations. And that's all for chapter 35. So if you have any questions, please feel free to raise those in class, and we'll see you in person on Thursday.